David, your latest article for The Atlantic is titled "The Colorado Supreme Court Just Gave Republicans a Chance to Save Themselves."
And in it, you write this: the U.S. Supreme Court now has the opportunity to offer Republicans an exit from their Trump predicament in time to let some non-insurrectionist candidate win the Republican nomination and contest the presidency. The Colorado court has invited the U.S. political system away from authoritarian disaster, back to normal politics, back to a race where the Biden-Harris ticket faces more or less normal opponents, rather than an ex-president who openly yearns to be a dictator. Until now, Trump supporters have been protecting Biden from his own weaknesses by insisting on nominating an even weaker alternative. If upheld by the Supreme Court, the Colorado court's decision might yet save the GOP from itself. Will the GOP consent to be rescued? And this reminds me of what Liz Cheney was saying on Fox News on Monday night, where she was saying there are other candidates who can stand up for this party and bring it back to its roots and actually wage a good fight for the presidency.
They could, I guess, David. The question is, as we look forward to what the Supreme Court does here, obviously you've got a Roberts court that, yes, is conservative in many ways, but also Roberts himself is conservative with a small c, an institutionalist. I think one of his most famous rulings was upholding Obamacare, where he said, don't ask us to do from the bench what you all can do from your voting booths next year. I'm wondering if that, despite the fact that this is a very strong legal argument, according to most conservative jurists, that despite that fact, the institutionalist in Roberts and the Roberts court will say, we're going to let the voters decide this.
Yeah. Well, that's why the remarks from Republican candidates over the past 12 hours or so have been so important. Because this court is highly ideological, it's highly political, it's very attuned to what Republicans want. If Republicans like Haley, like DeSantis, like others, give the Supreme Court, this very pro-Republican Supreme Court, sort of a permission, they may act. If not, they won't. You know, I like George Conway. I was president of the Harvard Law School Federalist Society the same year he was president of the Yale Law School Federalist Society. Like him, I was skeptical of this approach. But one reason I was skeptical, in fact, I wrote an article in August warning that the courts would never do it. But one reason I was so worried about it was I thought this case would probably arise in the summer, when it would be Trump versus Biden. But it's arising at the end of 2023, when it's not Trump versus Biden, it's Trump versus Haley, Trump versus DeSantis. So if the Supreme Court says, you know what, they're right in Colorado, Trump is an insurrectionist, the candidates they are boosting are not Democrats. The candidates they are boosting are fellow Republicans. If only the Republicans will accept the lifeline the courts could throw them.
I think we have George Conway back now. George, you were talking prior to your microphone problems about the dissent in this decision. You know, I read the decision last night and the dissent, and like you, I was struck by the language of the dissent in that it seemed to me non-ideological, non-threatening, non-angry about the majority opinion. And so let's continue with your view of what you read.
Yeah. I agree with that assessment, Mike, but it goes more than that. The dissents were logically weak. I mean, even if you don't have a lot of rhetoric in a dissent, you often have just this a logic that just slices and dices the majority opinion to bits. And there was none of that. There was nothing in this opinion. In fact, the opinion doesn't really talk about the real issues in the case. They don't dispute that Donald Trump engaged in an insurrection, and they don't dispute that Section 3 of the 14th Amendment bars people who engage in insurrection from running for president or anything else. And what they talked about mostly was state law, and state law doesn't matter anymore because the Supreme Court of the United States cannot overturn findings of state law made by the state's highest court. And not only that, even the things that the dissents were saying about state law seemed kind of trivial and weak. I mean, they were saying things like, "Oh, this is too complicated for our electoral litigation system," which is ludicrous because you know these systems do things like, you remember the Bush v. Gore in and the litigation about chads and everything like that, that can get very, very complicated. And these election litigation systems are designed to resolve that rather quickly. And people can go to jail in criminal cases on 5-day bench trials. The other thing was they said, oh, well, our Colorado law only deals with qualifications, not disqualifications. And that's just nonsense, because logically every qualification is a disqualification and vice versa. The Constitution says you have to be 35 to serve as President of the United States. And that means there's a disqualification. If you're 34 years and 9 months, forget it. And then the closest that they come to talking about the merits of the case was a legal discussion in one of the dissents about whether or not Section 3 of the 14th Amendment is self-executing. And the argument is that, and this is what the Trump people are saying, is, well, you can't just take Section 3 of the 14th Amendment, which says what it says, I mean, and just apply it. The courts can't just apply that because they need Congress to tell them how to do it. And that's ridiculous, too, because there are other provisions in the 14th Amendment, most notably Section 1, which contains the all-important Equal Protection Clause, which protects us all from race discrimination. Nobody says, and there's no textual basis for saying that that provision is not self-executing, because if it were, that means that you don't need a law from Congress to say that you can't discriminate against the basis of race. The same thing here. So the weakness of these dissents, and I always read the dissents first when I read appellate opinions, because I look for, like, okay, what's the weakness of the majority opinion? And I particularly look at that when there's an intermediate appellate court or state Supreme Court decision that could go up to the Supreme Court, and I read the dissents to see what the battle lines are. And I got to tell you, if Trump's going to win in the Supreme Court, he's got to come up with some better arguments than the dissents had. And if the Supreme Court is going to overturn this decision, those justices need to come up with better arguments.
Wow.